Hey guys, welcome to my legal classes. This is Ganesh Pujari, and in the series of Evidence Act, we were focusing on chapter 2, which is all about relevancy of facts, covering from section 5 to 55. In my last session, we have discussed on section 25, where we understood that the confession made to a police officer is not valid. Here in this session, we are discussing section 26, where we are understanding whether a confession made to a police officer when in custody or whether a confession is made to anyone else while in police custody is valid or not, or is there any exception for the same. All of that will be answered in this session. Not wasting any of your time, let's get into the first slide. Section 26 is on confession by accused while in the custody of police not to be proved against him. The title itself suggests that if someone is in the custody of police in such time, if the confession is made by such accused, that is not proved against him. It says no confession made by any person while he is in the custody of a police officer unless it be made in the immediate presence of a magistrate shall be proved as against such person. So it is not just about accused. If any person is making any confession to anyone while in the custody of police officer, that is not valid unless and until it made to a magistrate or in a magistrate's presence. That is what section 26 all about. When I am saying magistrate, we need to understand the term magistrate as per CRPC 1882. That is what given in the explanation. The same thing I have put in a beautiful chart. Let us try understand the chart. The chart says or starts from no confession. That means any confession made by any person. What do we mean by any person? Why are we not straight away calling accused? Sometime we will have accused and sometime the person may not be accused yet. So that is why we are using the term by any person. While they are in the police custody of a police officer, if any person is making any confession while they are in the custody of a police officer, such time if he or she makes any confession, such confession is not valid or they cannot be proved. That is what section discusses about. But before it concludes, it also gives an exception by saying if such confession is made in the presence of the magistrate, in that case such confession will be relevant, otherwise it is not. And the term magistrate we need to understand as per Criminal Procedure Code 1882. That's all about section 26. What is the object of section 26? While a person is in the custody of police officer, it gives easy opportunity to such officer do some coercion or to extort confession from such person. To avoid such undue influence or opportunity, section 26 is being inserted in the Indian Evidence Act. Along with that, it also protects Article 21 of Indian Constitution, which discusses about no person shall be deprived of his life or personal liberty except according to the procedure established by law. In my last session, we have done a detailed discussion to understand who is a police officer. In this session, we got a new term, that is police custody. What is a police custody? Let's try understand the term in my next slide. What is police custody? Or what is custody of police? Most of the time when we discuss about police custody, we get confused with arrest. What happens in arrest? In arrest, police will keep his hand on a person or use handcuff or tie hand or waist with the help of rope, etc. But in police custody, none of that is required. A police officer, without even touching another person, can take full control over him and he can take such person wherever he wants. Such a power is available with police. And when a person is controlled in that way, or mere surveillance or restriction of a police officer when takes control over another person is known as police custody or custody of police. Overall, what we need to remember when it comes to police custody is when a person is in the custody of police, he loses his freedom. That is one important aspect we need to remember. Now, police custody doesn't have any specific place. It can be in a hospital, it can be while traveling, it can be even when you are in home. They can keep few police officers or constable outside your home and keep a surveillance on your activities. That is also police custody. Or even in public place when a policeman is watching you, that is also police custody. So it can be anywhere and everywhere. I have an illustration here. There is one Mr. X who is being arrested by police, and while he was arrested, he had some severe injury. For that reason, he was being admitted to a hospital. When he was in hospital, there was no police in such hospital or there was any visit by police. No police visited such hospital. Even then, Mr. X is in the custody of police. That is what we need to remember. Police custody need not to have a police officer in front of you. Without even them, even in their absence, you might be in their control. That is what is known as police custody. As we are discussing police custody, let us also try to have an understanding of arrest. Just like police custody, for arrest also we don't have any definition. With the help of case laws, let us try understand what is arrest. In R.R. Chari versus State of Uttar Pradesh, it was held that the act of being taken into custody to be formally charged with a crime is arrest. There you can see custody in arrest also. So by doing arrest, police takes someone into their custody. That is what we need to understand here. In the other case law, that is State of Punjab versus Ajib Singh, it was held that physical restraint put upon an abducted person in the process of recovering and taking the person into legal custody with or without any allegation or accusation of any actual or suspected commission of the offense. If somebody has committed any crime or if there is a suspect that he is going to commit any crime, if police is taking him or recovering him, that is known as arrest. Here also the term custody comes in. Now police custody can be in the form of arrest also, but remember it need not to be arrest all the time. Mere surveillance or mere restriction is also considered as police custody. That way police custody is much larger version when compared to arrest. With that, I am moving to the last slide. In this part, let us try understand the important part which says not valid when made to anyone except magistrate. Now in my last slide, we were discussing about a police officer. It is not just about police officer. If any person is making any confession while he is in police custody to anyone, such confession is not valid. That way, it is not just about police officer. If you are making confession to anyone other than magistrate, it is not valid. To understand who is this anyone, the beautiful case law that we need to refer is R versus Lester. What happened here? There was an accused who was being arrested by a police constable and they were traveling in a tanga. In between, police constable gone away from tanga for some work, and in the meantime the accused confessed with the tanga driver that he has committed such crime. Now the confession made to the tanga driver is not valid because such confession made by the accused while he was in the police custody and he has made such confession to anyone, that is Tanga driver, that is not valid. I hope that is very clear. When a person is in the custody of police, if he is making confession to magistrate, that is a valid confession. Now, magistrate is the only exception available in this section. Now, who is this magistrate? There was a discussion in State of Haryana versus Padam Pramod case where there was a discussion whether magistrate includes executive magistrate or it is only judicial magistrate. The Punjab and Haryana High Court held that it is not just judicial magistrate. If it was only judicial magistrate, then it would have spelled out very clearly. As it is not spelled out very clearly that it is only to judicial magistrate, we need to cover it for both executive magistrate as well as judicial magistrate. That is what held here. Coming to the last part of the discussion, we need to remember that Section 25U and Section 26 of Indian Evidence Act are not applicable for the offences covered under TADA Act. Section 15 of TADA Act says if a confession is made to the police officer or during police custody are relevant. That is what we need to remember. That way, Section 25U and Section 26 of Indian Evidence Act are an exception to TADA Act offences. I hope that is very clear. And while reading Section 26, we need to read it along with Section 164 of CRPC, which discusses about recording of confessions and statements. There we are discussing in detail about the magistrate. That's my time on Section 26. Now, if you are rating Section 26 is interesting, then Section 27 must not be missed, because there we are covering certain fundamental rights also. Till then, thank you so much for subscribing my channel. Please like, share and comment my videos. All the very best for whatsoever purpose you are referring my channel, and thanks again.